So our final case set for argument this morning is Hitachi Medical Systems of America, Inc. versus JCZQ Family LP, et al., case number 28500. And each party will be entitled to 15 minutes to present your arguments now. The appellant, of course, has the right to reserve up to 5 minutes for rebuttal. If you plan on doing that, please let me know because I'll keep track of the time. Also keep your voice up because these are being recorded and will be posted on the court's YouTube channel. So please stand behind the podium and keep your voice up. We've read the briefs and are ready to proceed. When you are, will you be reserving time?
Yes, Your Honor, I'd like to reserve 5 minutes.
All right. Start by identifying yourself and the party you represent.
May it please the court, my name is Ryan James on behalf of the appellant JCZQ Family LP in this appeal. The question on appeal is simple. That is whether JCZQ is entitled to access information that was filed on its behalf to the court, which currently remains under seal. The trial court issued an order in December of 2016 denying a motion to unseal. Its three-pronged reasoning crumbles under any scrutiny. Here's why. The first basis for the trial court's decision was it ruled that JCZQ presented no facts as to why its representatives did not attend the in-camera hearing that was conducted by the trial court, purportedly in violation of a June 29, 2015 magistrate order. However, the in-camera hearing occurred on June 19, 2015, 10 days before the order which JCZQ allegedly violated. Therefore, that's an impossibility underpinning the trial court's decision. Moreover, the record does not indicate, beyond that fact, the impossibility, the record does not indicate any formal request for the in-camera hearing by JCZQ's prior counsel. There's no record evidence that JCZQ was provided with notice of the hearing. And there's simply no order of record scheduling the hearing or requiring its representatives to attend. Secondarily, the trial court imposed unreasonably a apparent good faith basis burden upon JCZQ to access its own information. It cites various cases, Pyatt, Bogart, and a third case, which escapes me right now, but the analysis that the trial court apparently applied governs where an in-camera hearing is requested in the first instance. Meaning you have to provide a basis as to why the hearing should be conducted. The hearing was already conducted in this case, that's not an issue. And those cases involve the potential disclosure of privileged communications to third parties. That's not what we have here. JCZQ is attempting or desiring to obtain its information, which remains under seal with the court. And finally, the third prong of the trial court's decision was that JCZQ was required to obtain consent from Zamora PA, a co-defendant, a joint defendant, which is currently engaged in bankruptcy proceedings in Texas. That is why the trial court apparently ruled that JCZQ was required to obtain the consent of the bankruptcy trustee in order to request the information under seal. Again, the trial court is misapplying the law of privilege. In this case, JCZQ and either the PA or the trustee are joint owners of the privilege. The PA up until the time of bankruptcy filing, and obviously the trustee after that time. Consent is needed if you want to disclose the information to third parties. Obviously that's Teleglobe, a well-known case which has been followed in Ohio. So consent is by all means necessary to disclose to third parties. In this case, JCZQ is requesting its own information. It's not going to be disclosed to a third party. It simply wants to review the information under seal to see what was provided to the court. At this point, it's impossible to know what is contained because our client hasn't had the opportunity to view what's under seal.
Was your client even a party to the lawsuit at the point in time when this was happening?
Yes, and I'd like to apologize for the record in this case, although I didn't create too much of it. It's tortuous and a bear to go through.
I love that word, but it often fits.
Yes, especially that I've seen some bad records, but this one's up there. But I was going through it again, unfortunately, yesterday, and the last order prior to JCZQ's former counsel's motion to withdraw, which I think was March 13th of 15, by the trial court, specifically states that JCZQ and the PA are entitled to pursue their claims for consequential damages. And I think the court also held that certain portions of Hitachi's contracts are unenforceable. But within that, the last order prior to the motion to withdraw, the court specifically stated that JCZQ could pursue its claims for consequential damages. Now, there are many conflicting orders in this case. But I think telling is, in January of 16, when Hitachi moved for a supplemental judgment entry to correct the judgment entry that had been entered in October of the prior year, Hitachi understood that JCZQ had amended counterclaims existing. It asked the court to enter a supplemental judgment entry as to JCZQ's amended counterclaims. So while there may be some confusion, admittedly, in the record, which extended for 6 years, just prior to the time the motion to withdraw was filed and then subsequently the in-camera hearing was held, JCZQ had amended counterclaims pending pursuant to the trial court's orders.
Somebody read about certain stipulations that were entered into indicating that your client's counterclaim had been dismissed or was no longer pending. Weren't there like 2 or 3 stipulations that were noted in the briefs that that indicated they were no longer a party, that they've been dismissed out?
They were never, JCZQ was never dismissed as a party from the action. And several of the orders or purported stipulations cited by Hitachi predate these other orders from the trial courts setting up what claims were going to be tried at trial, including JCZQ's amended counterclaims. But
So there were not stipulations, or were there?
it looks like there were.
I guess it was.
I'm
was
sorry.
the remaining party in the counterclaim for breach of the service agreement.
It looks like there were some type of sort of stipulations and then contrary stipulations later on, and contrary court orders and contrary filings. It's really unclear.
Stipulation, I think, of 2 parties agreeing, put it in writing and submitting it to the court.
I don't recall seeing any
Nothing
specific
like
stipulation to that effect.
Thank you.
And the parties understood that these claims existed just prior to the time that the motion to withdraw was filed. And thereafter. I mean, Hitachi itself recognized that fact in its filings with the trial court.
Well, your opposing counsel says that there may not have been written stipulations, but there were oral stipulations during the hearings in the trial.
And again, all I can say on that issue is the record is, again, tortuous. There's statements to that effect. There's statements not to that effect that contradict that. And really what I think needs to happen if this case gets back to the trial court is there needs to be another conference or something and figure out what claims actually are going forward here, because both the trial court and I think the parties' filings have not had the opposite effect. They may have attempted to clarify what remains in terms of claims, but I think it had the exact opposite effect. But the fact remains that the motion to withdraw, and in connection with which the in-camera hearing was conducted, was filed on behalf of former counsel for JCZQ. Therefore, its interests were, for lack of a better term, litigated during the context of that in-camera hearing. And then indeed the court's order allowing for withdrawal provides that counsel is entitled to withdraw on behalf of defendants, JCZQ included. So clearly its interests were discussed and addressed during the context of that hearing.
You've got about 6 minutes left, just so you have an idea.
So-
I reserve 5.
Reserve 5.
I'm sorry. So is your argument that even if they weren't a party
JCZ, even if no claims were pending, correct, JCZQ is technically, as far as I can tell, still a party to the action. The motion to withdraw addressed its interests among several of the other defendants. Therefore, the in-camera hearing addressed its interests, and its information was provided to the court. What that is, we don't know. But I think on those grounds, it's entitled to at least view what's there. It may be nothing, it may be something we just don't know. It's impossible to tell at this point.
That puts you right about 5 minutes.
Thank you,
We'll reserve the rest of that for,
if I could.
okay.
Thank you.
All right, the appellate of 15 minutes.
May it please the court, my name is TJ Evans and I represent the plaintiff, appellee, Hitachi Medical Systems America Incorporated. The underlying lawsuit was a collection action. Despite the 36-page docket, the parties' business relationship is relatively simple. Defendants structured their business so one entity, JCZQ Family LP, purchased 2 MRIs from Hitachi, and a separate but affiliated defendant entity, Jorge Z. Zamora-Quezada, MD, MPH, PA, which I'll refer to as the PA, entered into service agreements for those MRIs. Ultimately, the PA failed to make agreed payments under the service agreements, which gave rise to the underlying lawsuit. Throughout the 4 years of litigation, the court's orders and the parties stipulated that the claims existing in the case were Hitachi and the PA's competing breach of contract claims under the service agreements, and the and JCZQ's various claims under the purchase agreements. As of April 22nd, 2014, all of JCZQ's counterclaims were dismissed. This is the fundamental flaw in appellant's entire appeal.
So there's an entry that exists.
Absolutely, Your Honor. The April 22nd, 2014 order, which is document 186, closes in the end, and I will concede that it states JCZQ, but there's a non-protunct order later that demonstrates that the sole remaining parties remaining in the claims are Hitachi's claims against the PA for breach of the service agreement, and the PA's claims against Hitachi for breach of the service agreements.
And when is that non-protunct supposed to be?
There was a non-protunct, there's a magistrate's decision, 10/24/13, which is document 163, and then an order non-protunct, 11/7/13, which is document 175, and then ultimately adopted by the trial court, 11/20/13, which is document 178.
But I thought you said the original one was 2014, number 186.
That was- Yes, Your Honor, that was document 186. There was a,
But how can you non-protunct a 2014? You gave, I'm sorry, but maybe I misunderstood you, but I got the impression you were saying it was a non-protunct of the 2014.
sure, the non-protunct, I don't have the number in front of me, but was dated July 1 of 14.
Oh,
There was a prior magistrate's decision in court adopting it that set forth the status of the claims, as I previously set out, before JCZQ's claims were dismissed. And after JCZQ was dismissed as a party, the trial court would ultimately render judgment in favor of Hitachi, based in part on what the trial court called gamesmanship. Such gamesmanship included, not the least of which, was disobeying the trial court's order requiring defendant representative to appear at a hearing on defense counsel's motion to withdraw. After defendant representative failed to appear and the former counsel withdrew, the defense sat silent for months, ignoring several magistrate's orders, and only after final judgment was entered did current defense counsel enter an appearance in this case and appeal the underlying judgment.
I'm sorry, I'm not understanding. If they were already out, why was there a motion to withdraw?
The prior defense counsel was withdrawing on behalf of the PA, and in its motion,
Okay, on behalf of the PA then.
yes ma'am, and in the motion, I will concede that prior defense counsel withdrew on behalf of 8 separate entities that were involved in the case.
It was not that clear.
But the record is clear that as of April 22nd, 2014, the defendants were out of the case. And that's reflected in the defendants' own documents. In document number 274, I will read that verbatim. It's a brief filed by defendant Jorge Z. Zamora-Quezada, MD, MPH, PA, which is defined as the defendant, which ultimately states, I quote, and this is November 14, 2014, As the case stands today, plaintiff has one remaining claim against the PA, amended count 1, and defendant has 2 remaining claims against HMSA on counts 3 and 9. Even a cursory review of the amended expert report, which the PA filed in 2015, defines the practice as the PA. So, the trial court properly used its discretion and denied the order denying the motion to unseal the transcript, which was filed 14 months after JCZQ was dismissed as a party. The motion came 16 months after the in-camera hearing was held and 12 months after the final judgment was rendered. The underlying motion is nothing more than gamesmanship. The trial court agreed and properly used its discretion to deny JCZQ's motion because it did not indicate approval of all parties, and JCZQ failed to set forth any good faith basis. Because the order properly denied the motion, we respectfully request that this court uphold the order, because as a threshold matter, this court does not have jurisdiction to hear the appeal because JCZQ lacks standing. Second, JCZQ failed to obtain the necessary parties' consent, and third, JCZQ is not otherwise entitled to the transcript under Ohio law. You heard opposing counsel mention several times today that it was trying to access its own information, but then next it said it's impossible to know what the in-camera hearing contains. That information, at the very least, contained the information of the PA. The only party with standing to appeal the order is the PA, and it's not here today. That information clearly pertained, at the very least, to the PA. And if it doesn't know what's in there, it could relate solely to the attorney-client privilege of the PA. The PA is unable to defend itself here today. And allowing JCZQ to have carte blanche access to the in-camera hearing would invade the PA's attorney-client privilege. JCZQ does not have a present interest in the underlying claim. Appellant's brief mischaracterizes the claims in this case, though it tries to say that the record is unclear. It's very clear based on the several stipulations and several court orders after the April 22nd, 2014 order. Hitachi has pointed out the flaw in its appellate brief, and it laid out the extensive history in the case. And I'm happy to walk through that again or to field any questions. But appellant's reply completely ignored the citations to the record. JCZQ is also not prejudiced by the lower court's order. First, because they weren't a party, there can be no prejudice to JCZQ. And even if the court finds that they were an active party at that time, JCZQ represented to the trial court in its motion, and I'll quote, "The granting of this motion concerning the collateral issue of the unsealing of a transcript will have no impact on the Court of Appeals review, affirmance, modification, or reversal of this court's judgment entries which were entered in this action." That's document 444. And that makes sense because the record in the judgment appeal is already closed. JCZQ already filed its appellant's brief 4 months before it moved to unseal the transcript. There's simply no reason for it. But surprisingly, for the first time on this appeal, JCZQ now states that the transcript from the in-camera hearing is necessary to determine whether it impacts the appeals. That's completely contrary to the representation to the trial court in its initial motion. And that likely makes sense because making that argument in front of the trial court, it wouldn't have jurisdiction to consider it because it wouldn't be a collateral issue. It would directly impact the current appeal. The conflicting argument just appears to be further gamesmanship by JCZQ. Additionally, JCZQ failed to obtain a necessary party's consent. Even if JCZQ can establish that the information at the hearing pertained to it, which it doesn't, it still needs the consent of the PA. As I mentioned before, that information clearly pertains to the PA. Former defense counsel moved to withdraw on 2 bases. One was a lack of payment, and one was lack of communication concerning trial matters. The only parties prepared to move to go forward with trial as of June 2015 when the motion to withdraw was filed were Hitachi and the PA. It cannot be disputed that the PA was a party, and in fact was the only party at that time. So JCZQ cannot establish that the information actually belongs to it. In fact,
Was the same attorney representing both PA and JCZQ?
yes, Your Honor. There have been approximately 4 sets of different attorneys that have represented the defendant entities over the course of the lawsuit, some of which were terminated to derail trial dates. And I get the confusion with the record as defense counsel, current defense counsel's coming in post-judgment and trying to review that. Out of the 36-page docket, I was here for 33 pages of this docket. It was my entire career so far that I've been involved in this case. I've been to the transcript, or been to the hearings, and I would point to this court to the transcripts that were held on 4/30/14, so 8 days after the trial court entered its judgment, which is document 205. The July 22nd, 2014 transcript, which is document 253, and the July 13th, 2015 transcript, which is document 440. And then finally, the trial court properly denied the motion because JCZQ is not otherwise entitled to the transcript under Ohio law. The trial court properly held that JCZQ failed to set forth any good faith basis as to why it has requested the transcript to be opened. First off, it simply wasn't timely. It was filed 30 months after JCZQ was dismissed from the case, 16 months after the motion to withdraw, and 12 months after the initial judgment. And then it was filed 4 months after they filed their brief in the merit appeal, which is currently stayed. They also have to establish that there's a meritorious defense. But JCZQ failed to provide a single reason, even on its argument today, they failed to provide a single reason why that transcript is necessary for anything. It certainly cannot be used in the merit appeal at this time, and there's simply no other basis for it. It's just simply gamesmanship to avoid collection on the valid judgment. They also need to establish relief under Civil Rule 60B. And the only record evidence is defendant's bald assertion that, as a party, quote, as a party to this action, JCZQ is undeniably entitled to receive a copy of the transcript. As I've described, JCZQ is not a party. But even if they were, it's not simply just JCZQ's information. At the very least, it's the PA's information, and they would need the consent of the PA to see that, and they're not here today. Opposing counsel also references the January 2016 supplemental judgment entry, which states the remaining claims by the defendants are dismissed. Well, at that time, there were no remaining counterclaims by defendants. It's just a belt and suspenders approach to confirm that everything was dismissed and that the April 22nd, 2014 judgment entry by Judge O'Brien was adopted by the court. Defense counsel also heavily relies on its entire first argument on a scrivener's error. It said that it had no notice of the motion to withdraw or the in-camera hearing. It's beyond dispute that former defense counsel appeared at the hearing. And under the 9th District's precedent, an attorney's notice or knowledge of facts is considered notice to the client. The defendant absolutely had an opportunity to appear at the hearing. And even if they didn't, they had several subsequent opportunities, and I think going through the timeline is important. On June 10, 2015, defense counsel filed its motion to withdraw. On June 19th, there was an in-camera hearing, which defendants did not appear. On June 22nd, the court ordered sealing of the transcript. Defendants did not move to set aside that order. On June 29th, the court ordered a further hearing and required notice to defendants. Again, defendants did not move to set aside that order. On July 13th, the hearing was held in court. A defendant representative failed to appear despite opposing counsel filing 2 notices in accordance with the court's orders advising that defendants had actual notice of the orders. On that same day, on July 13th, the court entered an order granting the motion to withdraw. Defendants did not move to set aside that order. On July 14th, defense counsel sent a notice in accordance advising defendants of what happened at the July 13th hearing. On July 27, 2015, the magistrate entered its decision awarding judgment to Hitachi and against the PA. Defendants did not move to set aside or object to that order. On August 19th, the magistrate referred to the July 27, 2015 decision and scheduled an evidentiary hearing and canceled the current trial date. Defendants did not object or move to set aside that order. On September 28, 2015, the evidentiary hearing was held. Defendants failed to appear. On October 1, the magistrates entered a decision awarding damages to Hitachi. Defendants did not object to that order. On November 11th, after the trial court adopted the decision on October 20th, defense counsel entered an appearance and filed an appeal. For 5 months, defendants sat on their hands, didn't participate in the court proceedings, and are now claiming due process, which could have been cured on multiple occasions by appearing or responding to any of the magistrate's decisions or orders. It's simply further gamesmanship in an effort to get a lower standard of review, which the lower court clearly did not abuse its discretion in denying access to the transcript.
30 seconds left.
Well, this appeal should be dismissed for lack of jurisdiction, or alternatively, the trial court's order should be affirmed because JCZQ failed to obtain the PA's consent, and JCZQ is not otherwise entitled to the transcript under Ohio law. Thank you.
Thank you. We'll hear rebuttal. Yeah, 5 minutes.
Well, initially, my condolences if this particular case has been your career because, like I said, this record is just brutal. And if you've had to live with this for that many years. Much of what Mr. Evans was describing is on appeal in the prior appeal. Those are issues dealing with the void judgments that were entered by the trial court. That appeal is currently stayed pending the bankruptcy proceedings in Texas. It was a nice summary of the various orders in that case. However, the issue in this particular appeal is access to JCQ's own information. Again, opposing counsel referred to various orders, purported non-pro-tunc modifications. Fact remains, in March of 2015, the trial court, and this is the immediately preceding order from the court prior to the motion to withdraw, that this matter comes before the court on objections to a magistrate's decision as to consequential damages filed by defendants of JCZQ Family LP and Jorge C. Zamora Quezada MD MPHPA, collectively referred to as JCZQ. The court goes through its analysis as part of its order. The court finds that the JCZQ defendants, which obviously includes JCZQ, are entitled to proceed on their consequential damages claim, and therefore are entitled to present evidence and/or arguments related to lost profits. And this is in March of 2015, post anything Mr. Evans was raising with the court.
Counsel, on a little different aspect of your argument, you argue that the trial court improperly put a burden on your client to have to show a good faith reason to unseal the record. Are you suggesting that you had to show no reason to unseal it?
It's again, without, what we know is the information based on the July 13th, 2015 transcript, magistrate hearing transcript, is that there were text and emails relating to JCZQ, the PA, maybe other defendants that were provided to the court. There's a 25-page transcript that was produced as a result of the in-camera hearing, but we don't have it, so we don't know what's in there.
Well, it's based upon a motion to withdraw. Counsel, what would that possibly have to do with anything that's pending anywhere?
That's a great question.
No, come on.
Well, it is referred to in
You know what's on appeal.
Sure.
What does that possibly have to do?
It is referred to by the magistrate in its July 2015 decision, entering what our position is a void judgment against the defendant.
Well, then certainly the time to have asked for it would have been quite some time ago, correct?
There was a time gap. This court in Bauman ruled that a 3-year period between the time materials are sealed and the time a motion to unseal is requested was reasonable. And the Bauman court also held that a motion to unseal filed after an initial notice of appeal was filed in the case. This court has jurisdiction to hear that under a second notice of appeal. That's what happened in this particular action. So this court has held a 3-year gap is reasonable.
Is that cited in your brief?
It is, Your Honor.
Thank you.
And of course, what's reasonable is based on each fact of the case, that's why it's a
Correct.
reasonable standard.
And then finally, Mr. Evans made reference to a 6dB motion to vacate. My understanding is there was a notice of appeal already filed with regard to the void judgments. I don't think the trial court would have had jurisdiction to entertain the 60B motion at that point. Therefore, that's why relief was sought under 250502 as a summary application. And on those grounds, Your Honor, JCZQ respectfully requests that the court reverse the trial court's December 20, 2016 order and direct the trial court to release the materials to JCZQ and its counsel only. I will note Hitachi has at certain points requested copies of the information, which is wholly improper. Even Mr. Evans has made the argument that he believes it contains privileged information as to the PA, but that again, is not information that should be disclosed to any third parties, including Hitachi. Thank you.
All right, thank you, Attorney Evans and Attorney James, for your presentation. Court will take the matter under advisement. We'll issue a decision in due course. Clerk of Courts will mail you a copy of the decision on the day it's released. You can also check the Supreme Court's website where the opinions are posted. Unless there's anything else, we will be adjourned until